We ain't here with our expert today. Today is child support, family law court today on the Kenny Smith Morning Show. That's right. Sissy Brown, tell them who we got in the studio today.
We have our resident attorney. He's back, y'all. Attorney Daniel Marshall is here. Thank you so much for coming back.
My pleasure. Good morning.
Good morning, man. How you been?
Everything is good, man. How's it going for you?
It's all good, man. I see you got the whole beard thing going on over there.
Yeah, got the salt and pepper going.
Yeah, salt and pepper. You know, trying to get this grown man on over there. Not mad about it.
All right.
So we got a whole lot of different types of questions, and people want to ask different things. Today is your day to take care of your free game business today, people. If you got a question, you might be able to, give yourself some insight on what you're going to walk into.
Right.
Take advantage of the Kenny Smith Child Support Family Law Court when it's in session. You better. Okay.
Where's the gavel? We need a gavel.
I need a gavel, man. Go get me some kind of stick or something. I'll make it sound like it. Get something going on up here. But we already got questions, Mr. Marshall. So can we go get some? We gonna get one. You're gonna think about that one. Then we gonna start answering all your questions.
Yes.
Okay. So let's get the first one off the gate right now.
Good morning. I need a recourse. My baby daddy went and filed his income taxes, took all the money, as I have the child 90% of the time, pay for child care and everything, and of course he didn't give me a dime. What do I do to get my money from this, from this joker?
Calm down.
What recourses do I have to get my money back or to file him, complaint against him with the IRS, whatever I need to do to get my money?
So how does she get her money? Attorney Daniel Marshall in the studio with us today?
Yes, indeed. A lot of answers to questions are going to be based upon whether there's a current court action. If there's a current or past court action as well, then the permanent parenting plan order that the judge put down usually is going to set forth who can file taxes for the child and when. Sometimes they will have the parents to alternate years, like even and odd. Sometimes it'll only be one parent, but that would be the governing document if that document exists. If there has been no kind of court action, then gather together the information, the proof that you have that you are indeed the custodial parent, and present that to the IRS, and then they go through a process to see about any kind of recouping and that sort of thing.
Wow.
So what if the mom pays all the daycare and then the dad takes the daycare receipt from the daycare and files the taxes? Is that
sounds like fraud?
Yeah, that,
included in his taxes.
Yeah, Kitty, that does sound like fraud. Again,
just because he's the father.
Right. Yeah, so again, in that situation, assuming that there's no court action, she should get all of that documentation together and present it to the IRS. In that particular case, the documentation would include whatever kind of affidavit that you can get from the child care facility that indicates she's the one who's been paying it all of this time.
All right, guys, you better get your free game in here right now. 615-737-9292. We got another question.
I have a question. So my son's dad refuses to give me the information for his health care, his dental. What do I do? Because the insurance company won't give me any information.
What she need to do with this one?
So again, it depends on whether there's court action or not. If there's court action, then most likely within, again, what's called the permanent parenting plan order, the court has set forth who is going to be taking care of health insurance and through what mechanism, et cetera. If the court has done that, then you need to go essentially for a contempt action against him to make him comply. If there's been no such court action, then you need to get yourself into court to get that handled, because he doesn't have any kind of mandate legally outside of the court action for him to provide that. In other words, the court is the one that orders this sort of thing.
All right. You're not a court order. You better go get one. Hey, it's free game up in here today. Ask the expert.
I got questions.
The Child Support Court on the Kenny Smith Morning Show. Ask the expert. Hit us up right now.
You're listening to Ask the Expert on the Kenny Smith Morning Show. Get in on this free game now. Call us with your questions.
He has 3 other kids that he's already on child support for. So with this being his 4th kid that will be on child support, will I be getting less for my child because I'm the last?
Good question.
Yes. You'll be getting
wow,
less.
man. He said one word. Yes.
Yes.
Essentially, one of the many things that a non-custodial parent can get credit for is court-ordered child support that the individual is paying. So the more things that person is getting credit for, the lower the income that is used that ultimately determines that person's share of child support.
That makes sense.
All right, let's get another one. 92Q, what's up? What's your question for the expert?
Hello, the judge awarded my child $450 a month last year, I believe, but my son's father has not paid one dime towards it. Is there anything I can do, or should I just wait until the courts handle it?
Well, the courts aren't going to handle it what we call sua sponte, which means on the court's own motion. Instead, you've got to file some sort of petition, in this case, a contempt petition, to say, hey, he's not doing what the court ordered him to do. And as a result, we want him either to do jail time for 10 days for each instance of his not doing what he's supposed to do, or in the alternative, another route wherein he essentially has the keys to the jail where he can pay a purge amount to get out and then hopefully get back on track.
So what's the point of going to jail for 10 days, 20 days, however long? Because then you can't pay your child support. So why did the court put the men in jail, and then it's just going to make them go back further in arrears because they can't pay it?
Well, so depending upon the individual, going to jail and getting an opportunity to have to braid Dewante's hair is a deterrent. You see, that is a deterrent for some folks.
Okay.
Some folks don't enjoy the nice jail experience. And then a person who has any pride, who's out here, who's got a job, etc., doesn't want that interrupted by some sort of jail sentence and then come back and might not have the job available. So it can serve as a deterrent to folks. But again, there are two different tracks. One is, the criminal justice system a lot of times is about punishment. So if you go the criminal contempt route, it's to punish them. And a lot of times people might go that route after the person has shown that the civil route doesn't work.
Okay.
They get a chance through the civil contempt, it might pay a little purge of a couple $1,000s or something towards, $7,000, and then come back out and do the same thing. That at some point, then that's that other option of criminal contempt.
Let me get another question here before we get a break. 92Q, what's up with your question?
Good morning. I have a somewhat difficult question for your guest.
Okay.
I had a non-custodial parent that is now deceased that owed over $26,000 in back child support.
So,
is there any way of me recouping any of that for my daughter's college?
Wow.
And where would she recoup it from?
I'm saying.
So, one of the first things one can do is see about whether an estate has been open regarding that individual who passed away. If not, someone needs to get an estate open to the extent that that individual had assets at the time of death that one can plug into to get what is a valid debt taken care of. One would then stand as one of the creditors, in the estate. So that's one thing. Another thing is that Social Security benefits might be available for the minor child as a result of the other parent having passed away.
Okay. All right, guys. Hopefully this is helping you out. It's helping me out. I didn't know none of that.
Attorney Daniel Marshall.
615-737-9292. You're asking the expert. It is the Kenny Swift Morning Show, Child Support Court. You better listen up.
You're listening to Ask the Expert on the Kenny Smooth Morning Show.
My son is now 23, but his dad was in arrears for child support like $45,000. Is there anything I can do to recover any of that?
Yes. It doesn't matter the age of your son in terms of the arrearage. If he's in arrearage, that means that he wasn't paying pursuant to the court order. So definitely you could go the contempt petition route and get the court to set an appropriate amount for him to pay towards the arrearage based upon a number of factors, including his income.
Wow. Right. Okay. So even though after he turns 18, you still owe that money, is what you're saying?
He could be 40.
Yeah, that is correct. He could be 60.
Okay. Okay.
Wow.
Okay.
You owe the money. Pursuant to the court order.
Right.
That's right.
All right.
That is your cue. Question for the expert.
Good morning. Hi. I'm calling in reference to back child support. Once a child turns 18, and the court order says when the child turns 18, the arrearage amount goes down to $20. But I am still being charged the full amount. How do I do that?
So you're paying the child support?
Yes.
Okay. We're going to answer that on the air, okay?
Okay.
So she's paying the child support on this one. So how does this get handled? So, not that it matters if she's male or female, right? But
no,
sure, it doesn't. So unfortunately, a lot of people think that things happen automatically when there's some sort of court order, but you have to go in and, if the child support people, for instance, if they're involved in the case, if they don't catch it, you've actually got to go into the court yourself on a motion to say, hey, child is 18, has finished high school. Now I should just be dealing with the arrearage. So we want you all to order the child support people to get it down to 20 in terms of what they're expecting me to pay.
But if you don't say nothing, they just going to keep charging.
Yeah, there's in other words, there's nobody at child support or at the clerk's office, as far as I know, who's monitoring your case, and then magically when the child is 18 finish high school, they're going to say, hey, we got to just go to the arrears now. That doesn't normally happen, so you've got to take action yourself once it gets to that point.
Now, would it go back if they're being charged and they go in and they say, okay, go to $20 after they're 18? Does that go to $20 or does it stay?
So you're asking me about what we call nut pro tunc, essentially, and yes, it can go back to that date.
Okay.
Honestly, it might vary from judge to judge. To be honest, that's not something people want to hear, but you certainly can ask for it to go back to that date of that triggering event.
Gotcha. All right. One more question, see if we can get one in here. Now, if you got a question for Daniel Marshall, and when we wrap this segment up, give him his contact information. We're going to get you his contact information because we want you to make sure you can reach out to him. The man knows what he's talking about when it comes to this child support court and his family law. 92Q.
Yes, I'm calling in reference to taxes and claiming your child. So I had a recent incident where I went to court and the judge denied alternating claiming the child on taxes. The mother hasn't worked in over 9 years. Pay $800 in child support, never missed a payment, but he granted her her boyfriend to continue to claim him on his taxes. Should that be something I revisit in court? And then also, as of recent, she's got a job. Should I go and modify child support?
Wow.
So certainly judges make mistakes sometimes, but sir, I've never heard of a judge granting a mother's boyfriend the right to claim the child of someone else on the taxes. So that's not something I've heard of. So I think you might be mistaken, but if you're not mistaken, certainly the judge was mistaken. And yes, that's something that you should revisit. Generally, you would have, depending on which court you were in, about 30 days to do an appeal with regard to that. So that's something that should be revisited. As to the modification, there have been a number of questions about that, and without making it too complicated or getting into a lot of legalese, understand that just because someone's making more money all of a sudden, that doesn't mean that you're going to get some sort of upward modification of child support. Same thing if the person's making less money, doesn't mean you're automatically going to get a downward modification.
Okay.
Instead, you got to go through this process that might be complicated to a lay person, wherein you go through all the calculations to see what the new child support amount would be. And if there is what we call a 15% variance between what the old child support amount was and what the new one is, then you get that modification. So, having said all that, sounds like you need to hire a lawyer for that kind of thing.
And the lawyer is
Daniel Marshall.
Daniel Marshall. 615-753-2477.
One more time.
615-753-2477.
Give them a call, guys.
And y'all can call or text to that number. A lot of times I'm in court, so feel free to text as well. I'm happy to help however I can.
You have some shout outs?
You got a shout out real quick?
I do have a shout out.
Okay,
Come on, man.
Thanks for asking.
What I want to do is shout out the people of Nashville in the wake of these tornadoes.
Oh, yeah.
What I saw personally when I went to help out is just so many people coming together of different sizes. People brought their children with them, different races, to just pitch in and help out in the community. And particularly, of course, I'm concerned about the North Nashville community and other places that are heavily populated by black folks and our seniors, et cetera. But people just came out in a really big way, and it just made me proud. You know what I mean?
Absolutely.
Yeah.
Absolutely.
That's
so
right.
He had to give y'all a shout out on that one, man.
Yeah, definitely. I felt a little emotional being involved in that.
Oh,
no tears fell, but they kind of
lump in your throat.
He kind of welled up.
You got a lump in your throat. You got a lump in your throat. We understand.
Yeah, I got a lumpy throat.
Players get emotional. Players
get emotional.
Daniel Marshall, thank you for coming through, man. We appreciate you every time you come in here,
Thank
man,
you so
dropping that
much.
knowledge and helping out these good folks.